Prayer. Thank you. Opening prayer, a bit of welcome and introductions that we're working on right now. In a moment, I'm going to hand this to Michael to talk a little bit about theology, the purpose of Title IV and the theology around that. And then we'll also look at the participants in the Title IV process. What are some of those roles? We'll then do kind of an overview of the entire process. There will be breaks for questions and answers. We will do a case study in small groups once we hope everybody's kind of got the lay of the land, and then we'll debrief the case study. So that's what we're planning to do tonight. And we do anticipate taking about a 10-minute break, a 5 or 10-minute break, probably around 6:30-ish, if that works for folks. And of course, if you need to step out for a moment or two, please do what you need to. Originally, this was scheduled to be a full day live training on a Saturday when it looked like COVID had settled down. And then when we had to postpone the live training, Michael and I thought about this and said people might prefer to come to a chunk of an evening, a weekday evening, rather than trying to find a Saturday even to do this online. So that's why we're here tonight. So Michael, this is a little bit of a brainstorming session. Michael will run this. Who's impacted by clergy misconduct? You can take it away, Michael.
Wonderful. And Robin, may I ask you to continue driving the slides rather than trying to pass the screen sharing back and forth?
Yes, just tell me when you want me to go.
Terrific. Thank you. So we're starting by zooming way out and not looking at the nuts and bolts and the nitty-gritty of Title IV, which is interesting, but it's not really the point. It's the support. The point is to think about what misconduct is, which we'll talk about a little bit later, and who is affected by it, and who needs to be part of the effort to seek reconciliation and justice, and all of the things that we'll talk about shortly, the purposes of Title IV. It's really easy for me. I'm like several of us on this call, I'm a former lawyer. Some of us are current lawyers. And one of the things that I carry forward from my day as a lawyer is a sense of sort of who is involved in issues that is narrower than is actually helpful in the context of the church. Lawyers often think about, who had a duty, who breached a duty, who was harmed, where was cause proximate, lots of Latinate words, trying essentially to draw the circle of participants in a legal matter relatively tightly. But as everybody knows, the people who are actually affected by conduct can be way wider than the ones who actually end up with a voice in a courtroom. And Title IV, as we'll talk about, is not a court at all. So when you look at the picture of who is impacted by clergy misconduct, you kind of see everybody, and in a way that's appropriate. Here's the church, here's the steeple, open the doors, and all the people are affected. We do need to do some line drawing. Not everybody is equally affected, but imagine a piece of misconduct. One of the case studies that we'll use later tonight involves potential financial misappropriation by a priest from a discretionary fund. The key actors in that misconduct are the priest, obviously, and the congregation institutionally as owner of the discretionary fund. But think more broadly. Think, if you will, as best you can with God's mind, about everybody who might be involved or affected by that kind of conduct. Obviously, the congregation as a whole can be involved to the extent that there is a sense of betrayal or hypocrisy. If the priest has been talking about something and doing something different, the effects can be wide and broad. There are certainly primary victims. There are the people who are most obviously affected by, for instance, sexual misconduct. Those would be the people with whom the sexual misconduct took place or against whom it was directed. But more broadly, the congregation as a whole, leadership in the congregation, vestry, particularly, maybe a search committee who called the priest to the congregation and who now is feeling a sting of betrayal in particular. Staff members. I'm not going to delineate all the different people because the point is that it's important to pull back and think broadly about who the different people may be who are affected by misconduct. One of the things that we need to do in the course of Title IV is to make sure that people who are affected by misconduct are cared for. That's its purpose. And so think broadly and creatively about who it is who might need care, who might need reaching out to. That's particularly important for those of us who are intake officers or who work in the Title IV process, sort of helping to structure things at the outset to make sure that the correct processes are in place. One of our obligations is to make sure that there is pastoral care extended to those who need it and those who are affected by misconduct. And it's important to, again, think broadly about who that might be to make sure that those who are hurt, whether they're the obvious ones or not, are being cared for. It may also not be the people who are victims or sort of adjacent to victims, but it might be the people who are adjacent to the perpetrator or the potential perpetrator. It might be the clergy person's family who may very well need care, friends. So again, without belaboring it, just try to pull back broadly and see broadly all the different people in the system who might be hurt in a way that requires the love and the care of the church on behalf of a God who is, after all about reconciliation. It's helpful at this point, I think, to think about the goals of Title IV, because we've been referring to them obliquely so far. But on slide 5.
Can I just interrupt, Michael? This slide
please.
Is just a group of people who've been impacted by clergy misconduct. This is just a slide where a group got together and brainstormed. So it just follows up exactly from what you were just saying, Michael.
Thank you.
It's just a breakdown of some of the people in parishes and beyond parishes that are harmed when there's clergy misconduct.
And it's a helpful kind of cast your eye over it to help you think categorically and broadly about people who might need help, people who might need care. I love that future generations is on there. They probably can't receive pastoral care directly, but many of us who deal with historical cases of sexual misconduct realize that even 50 years later, the repercussions are still repercussioning. Yeah. Let's continue on to slide 5. Slide 5 essentially paraphrases the canons of the church. Title IV, I imagine that everybody knows, but shouldn't assume anything. When we refer to Title IV, we're referring to Title IV of the canons of the Episcopal Church, which is the set of canons that contain the disciplinary provisions of the church. It starts out with Title IV, Canon 1, which describes what the whole system is about and what its purpose is, and then it gets increasingly granular about the nature of misconduct and the kinds of proceedings that can help to accomplish the purposes of Title IV. But we always start as a church with the purpose. What are we about? What are we doing in God's name when we confront a case where there may have been misconduct? And of course, at the outset, we never really know. We know that there's a question, but as we'll talk about when we get to process and procedure, we don't know, and we don't assume the answer until we ask the question and investigate, listen. But the purpose of everything that we do is to support the members of the church in their life in Christ, recognizing that we are all fallible humans. We all make mistakes. We all occasionally misbehave. And in the church, sometimes that misbehavior rises to a level where it harms people or interferes with the life of the church as the body of Christ, and it needs attention. Long ago, before I was involved in Title IV, some of you may have been involved then, I don't know. Title IV was based on the Uniform Code of Military Justice. It was essentially a prosecutorial justice-focused model. Back in the early 2000s, there was a huge revision done to Title IV, which changed both its processes, but also its purposes. Title IV now is meant not to be a kind of an emulation of a prosecutor seeking to get a conviction, but it's meant to be much more a conversation about what happened, what is right, what needs to happen to bring about goals such as repentance, reconciliation, restitution. These are all enumerated in the beginning of Title IV in Canon 1. Justice, healing, forgiveness, amendment of life. One thing that I think is interesting about all of these words is that these all kind of assume that there was misconduct. And that bothered me for a while until it occurred to me further that if in fact there is a groundless accusation of misconduct, then I think actually some of these things are still necessary. Were somebody to make a groundless accusation, I think probably repentance and reconciliation and healing and amendment of life are still in order, just not quite in the way that might first seem apparent. So Title IV points us to all of these things, and these are all, after all, the values of the gospel. They're not necessarily the values of the Army. I have all respect for the Army, but I think that their emphasis is different. Our purpose is to be the body of Christ and to call ourselves back into body of Christness when we have fallen out of it. So that's what Title IV is for. It's been described as a discernment process. And by that, I mean most deeply a process of looking carefully, asking questions, listening to answers, and trying to put on the mind of God as best as we can in our human state, and to figure out what is happening and what should happen. So it's a series of conversations, it's an inquiry. The best conversations, as you know, are open-ended ones. We're not taking in a complaint like a police officer and seeking evidence to substantiate it or not. We're actually seeking to find out what's going on. And sometimes what's going on is not what it first appears, but it's still something. And so we listen as openly as we can. It's designed to help us, the Episcopal branch of the Jesus movement, to address the reality that we do fall short. We do sin against one another. We do cause harm. None of us sets out in our lives and ministry to do that, but we do. Sometimes inadvertently and sometimes quite intentionally. And when that happens, we need to redraw the boundaries. We need to create and hold accountability for those who've crossed them. And we need to protect those who've been harmed and do our very best to right the balance. That's where reconciliation and restitution and amendment of life and all those things come in. That doesn't just mean a smile and an apology. There are cases where that's not nearly enough and not nearly appropriate. But we are always seeking to live the values that Jesus calls us to, even when those values are hard ones. So it is an ecclesiastical process. It is based in our core gospel values, and it is not a military tribunal anymore, nor is it a civil or criminal court. If the processes go on long enough, if we start a Title IV proceeding, and if we don't succeed in bringing together the parties to figure out by agreement what should happen, if the bishop is unable to persuade somebody who has committed misconduct to take ownership of it, ultimately we can end up, and we'll talk about this later on, with a hearing, which can feel a little bit like the process of a court. But that's a last resort, and it's the way that we make sure that there's always a chance to be heard and have an adjudication. But it's not where we hope to go. We hope to go to the kind of resolution that comes about between people who are all seeking to follow Jesus, even if one or more of them has gone wide of that goal. So a discernment movement seeking repentance, reconciliation, restitution, healing, and all of those values Once we say that, we need to start saying more about what exactly Title IV provides. What does it look like? What does it mean to commit an offense? What happens? How do we know when somebody has done something that requires intervention, and how do we intervene? So for that, I'm going to pass back to Robin, who's going to talk about what a Title IV offense actually is.
Thanks, Michael. So as Michael set out, Title IV is really, it is on some levels a discernment process. You will see as I walk through what is considered an offense in Title IV, that there's lots of different behaviors that can come into Title IV at this point. And the important thing to keep in mind that you'll see a little bit later when we go through the process, there's lots that can come in, different types of offenses, and there's a multitude of ways for matters to be resolved. So I don't want anyone to be alarmed thinking, well, that doesn't sound like the most serious offense. Why would that come into Title IV? It can come into Title IV and be resolved on a level that matches the degree of violation that occurred. So you'll see the variety of ways that works out when we get to the process. But what I'd like to talk about just for a couple minutes is what is considered an offense in Title IV. Because there's lots of mistakes. Now, Title IV only addresses clergy behavior. It does not address behavior by lay people. There's a lot of mistakes clergy are going to make that are not an offense. So it's important to know what is an offense. And in a moment, I'm going to go through kind of a list of 3 categories of behaviors that could be an offense. And for each of those behaviors to be an offense, it must meet the standards on this slide. That behavior has to be material and substantial or of clear and weighty importance to the ministry of the church. And I can't emphasize this enough. Sometimes when I train clergy in the Episcopal Church in Connecticut, I show this slide 3 different times with material and substantial and clear and weighty in different colors to try to impress upon people that all the behaviors we're going to talk about are not an offense unless they also meet this standard. Of course, these are kind of legal sounding standards and there's not specific definitions, but I will give some examples as we go through these lists. And if you happen to print out the document that was about accountability, the columns I'm going to talk about now are pretty much the columns on that sheet. The first kind of clergy behavior and accountability standards have to do with accountability to the Title IV process. All clergy have obligations to the Title IV process. They have to cooperate with the process. That means if a clergy person is asked questions, if there's an investigation going on about another clergy person or even themselves, they have to cooperate. They've got to answer questions, whatever's being asked of them. Clergy are, sometimes I find it hard to believe we even had to write this down, but clergy are not supposed to bring false accusations in Title IV. I'm hoping that that's pretty apparent to folks, that you wouldn't bring false accusations. If there is a pastoral direction from a bishop, an order or an accord, a clergy person needs to follow those. And if they don't, it could be an offense. And an order is something that you'll see a little bit later in the process. An order can be issued if we ever get to a hearing, which, as Michael referred to, that's the most kind of closest thing we have to a trial. And that the hearing panel could issue an order and say, clergy person, you will do this. An accord is just the word in Title IV that means agreement. And you will see when we go through the process, many parts of the process, we're trying to see if we can come to an agreement with the clergy person, known as the respondent, and either the bishop or the panel that the matter is in front of. So if there's an order or an accord, which would be an agreement that the clergy person had entered, or a pastoral direction. A pastoral direction can be issued by a bishop at any time, whether or not Title IV is pending, in their capacity as teacher and overseer. And sometimes without Title IV pending, there are times that clergy, that bishops will issue a pastoral direction. All those three documents, they come about in different ways, but if there's one that exists telling a clergy person to do something, failing to do that can be an offense. The other and the last point on this slide is that clergy are required to report all matters which may constitute an offense. This was new in 2018, as was the cooperate with Title IV. That was new in 2018 as well. And this is kind of a big deal for clergy. This, in my experience, this is hard for clergy. This requires clergy to, in effect, report on peer clergy if they think their peer clergy may be doing something that constitutes an offense. And many times there are questions about this. So if you do have questions after we go through this piece of this, the offenses, we'll take a break for questions. So if you do have questions about that, please flag it. This is a very common requirement in many licensing processes for lots of professions. So for instance, I was a legal aid lawyer and still am a lawyer in good standing. And the Code of Professional Ethics for Lawyers requires me to report to the grievance committee when I see a lawyer violating that code. So this is very similar to that. Process accountability. Now, there are certain behaviors required of clergy, and it's following the canons and constitution of the church. Respecting and preserving the confidences of others. Again, this was a relatively new behavior that was listed as an offense. And this would pertain to if somebody tells clergy something and they expect it to be held in confidence, there is an obligation to hold that in confidence. Conforming the rubrics of the Book of Common Prayer. This does not mean that every time somebody makes a mistake and violates a rubric, that it's a violation, that it's an offense. Because remember, it has to be material and substantial or clear and weighty. So a case that we've had in Connecticut where somebody violated the rubrics and it was found to be clear and weighty was an ordained person in the Episcopal Church was allowing someone not ordained in the Episcopal Church to celebrate Eucharist. Okay, that's different than if somebody forgot to say the Nicene Creed some week. There's a qualitative difference between those. Clergy are required to abide by promises and vows at ordination, which for lay people, I happen to be a lay minister in the church. If you take a look in the Book of Common Prayer at what clergy promise, it's a ton of stuff. It's a lot. They're giving up a lot of rights that the rest of us have in the secular world. So, but it's to abide by all those promises and vows. And also, and this is a relatively new behavior that was added here, safeguard property and funds of the church and the community, which is a little bit tricky because, as you know, the vestry is the group that's has authority to pass a budget. However, if there's a clergy person with authority in a parish watching a vestry spend down all the endowment or make some kind of foolish decisions about funds, maybe using funds inappropriately, the clergy person has to try to do something to safeguard the property and funds of the church. And here's just a list. I think this list is pretty self-explanatory, but don't violate the canons. Your clergy are not supposed to engage in sexual misconduct, which is very broadly defined. It includes any kind of sexual behavior, which includes language alone, doesn't have to have physical touching. Any kind of sexual behavior with anyone with whom the clergy person has had a pastoral relationship or provided pastoral care. So that doesn't mean just in the current church where somebody may be serving or parish. It can include people that were in prior churches. Clergy are not to privately or publicly. Now, how you would know privately, I'm not sure, but not to publicly hold or teach doctrine contrary to the Episcopal Church. Not to engage in secular employment without the consent of the bishop. And this used to, when I started working on the bishop staff 22 years ago, it was pretty common for priests anyway to be employed full-time in a parish. That is not the norm now. The norm now is there's a lot of bivocational priests. And if you are having a job, if clergy are having a job in secular employment or somewhere outside the church, the bishop is supposed to be aware of that and consent to that. You're not supposed to be absent from the diocese for more than 2 years. Here's another one that I hate that we even have to write this down, but clergy are not supposed to engage in criminal acts or engage in dishonesty, fraud, deceit, or misrepresentation. And that includes in the ordination process. Apparently, there were some cases that people had misrepresented something about themselves in the ordination process that wasn't discovered till after ordination. And when diocese attempted to bring a Title IV action against that person, there was some dispute about whether they could be held responsible for something they did before they were ordained. So any kind of misrepresentation in the ordination process can now be an offense. Clergy are not supposed to habitually neglect the ministerial office. Relatively new is a clergy person cannot retaliate, demote, or discharge anyone who opposes the clergy person's behavior or reports the behavior to an intake officer, which is how something comes into the Title IV process. So this means that if there's a staff person or a lay leader who goes to a clergy person and says, clergy person, you need to stop doing whatever the behavior is. And the clergy person then takes some kind of retaliation, either changing a job description, demoting, firing, getting someone removed from a lay leader position. That in and of itself, taking that action to retaliate against a whistleblower, this is an attempt at protecting a whistleblower, could become a separate Title IV, an offense. And the last category here is conduct unbecoming a member of the clergy. And that category has been in Title IV since I've known about Title IV. And that is the category where if something happens, if we describe something and all of us went, ooh, that is really not good, but we couldn't fit it into any other categories we just went through, that's what conduct unbecoming a member of the clergy is. So we just went through a lot of information, and what I think I'm going to do, if this works for folks, is maybe stop screen sharing, ask Allison to pause the recording, and stop for questions and comments. Thanks, Allison.
Thank you very much. We're doing our best to make this presentation linear, but I know that questions are often non-linear. So as we continue talking, if you have a question about something that we did earlier that occurs to you later, don't hesitate to tuck it, to raise it out of order. It's just fine. What I want to talk about now, relatively succinctly, is all the different people and structures and groups who are the players, if you will, not to be blithe about it, but who are the participants, the players in the Title IV process? And there are a lot. So just going in the order that we have them to look at on the slide, the first of them is the bishop. And in a funny way, the bishop is always going to be at the center of a Title IV process because the bishop is an essential decision maker at several different stages. But it's also kind of funny to list the bishop first because part of the purpose of Title IV is to limit and guide the authority of the bishop. In days long gone, when there was no Title IV process and no other sort of formal disciplinary process, the bishop essentially had unfettered discretion. And that might have worked out well in some cases, but not necessarily in a lot of them. So so the bishop is both central and essential, but also limited and constrained in terms of what they do and when and how they exercise their discretion. One of the key ways that the bishop's discretion is limited is that the bishop's not the one who first hears about misconduct, or if the bishop does, they pass on that report right away, ideally, to the intake officer. Many of us are intake officers, and so as we talk about process, to some degree, we're making sure to think about how that role is played out. The intake officer is the one who first receives a complaint, or if anybody else does, they pass it to the intake officer. And as Robin will talk about later on, the intake officer's primary job is to figure out what exactly the complaint is and whether, if it's true, it constitutes an offense. And if it does, to pass it on to another group, which will then figure out what to do with it. So the intake officer is primarily a screen to decide whether we are dealing with a Title IV matter or not. It's an important role, and it's also a limited role. Every diocese, except for some of our dioceses, which share them among several dioceses, but every diocese has a disciplinary board, either its own or a shared one. The disciplinary board is made up of lay people and clergy, so lay people, priests, and or deacons. A majority of the disciplinary board is ordained, but only a majority by a bit. The disciplinary board is served by a president who is elected by members of the board, and the president is really important. The president is not merely the convening officer, but the president actually has a fair degree of participation in the process independently of the rest of the board. So when the board convenes and elects its president, that election really actually matters a lot. In large part because the president serves on the reference panel. Again, Robin will talk further about this, and I will in a second, which decides what to do with a matter once it has passed by the intake officer stage. The rest of the board does not serve on that panel, so the president has an important role figuring out how to steer a matter. The president, as I say, is elected by the board members. Other members of the board do have important roles if cases get far enough, which most of them don't. Most of them get resolved before the conference or hearing panel. But if a conference or a hearing panel needs to be convened, the members of those panels are members of the disciplinary board who have been elected by their diocese. So the intake officer receives a matter and decides that it should go forward and passes that on to the reference panel. We'll talk in more detail about each of these folks, but the intake officer, I guess we can't really do raising of hands here in Zoom, and I don't want to go out of screen saving. So I won't ask that question, but I know many of us are intake officers. They are people designated by the bishop to whom information regarding offenses is reported. You saw earlier that there's an obligation to report. In fact, it's an offense for a clergy person not to report an offense. The intake officer is the one who takes in that information and decides whether it constitutes an offense. Importantly, and again, Robin will say more about this in a minute, the intake officer is not, sort of judge, jury, and executioner rolled into one. They're not deciding what actually happened. They're just deciding what the complaint is and whether, if it's true, it needs to be processed under Title IV. Intake officers can be either ordained or lay people. In many dioceses, there's an effort to have one of each. There's also often an effort to make sure that there is a male and a female intake officer. I don't know if dioceses have begun thinking more broadly in terms of gender with intake officers in mind, but the point is to make sure that there is somebody to whom the widest variety of potential complainants possible will feel comfortable talking. I also think that it's a great idea for intake officers to be lay people as often as possible. because disappointed complainants often decide later on to file Title IV complaints against intake officers for not doing what they wanted them to do. And it's just great if the intake officer is not ordained and therefore not susceptible to Title IV, but that's just me. The next player in the system is the bishop. As I said, the bishop comes in a lot of different places. The first one is that the bishop is on the reference panel. If the intake officer decides that the matter does merit consideration under Title IV, the reference panel is the group that convenes to decide what to do with it. The reference panel can refer. It's called reference panel because it refers the matter on for several different kinds of process. But at any time during the process, whatever the reference panel does, the bishop can issue various kinds of directions to the respondent, to the person who is claimed to have committed the violation. It can be a pastoral direction. Robin talked about those earlier. It can be a restriction on ministry, or it can be an administrative leave. Those are all different ways that the bishop can essentially take action to protect the church or the complainant or everybody from potential further harm by the respondent. It's complicated because the bishop often has to do this based on a complaint that hasn't yet been assessed for truthfulness or for weightiness or anything else. But if there is an apparent danger to anybody, the bishop has the power to do these things to try to protect the system, the people involved from any further harm. So a pastoral direction is just what it sounds like. It's any kind of instruction to the clergy person. A restriction on ministry directs the clergy person to do certain things and not to do other certain things. An administrative leave is basically a suspension, if you will. It's an instruction to put down all aspects of ministry and step away until the matter can be resolved. An order, which Robin will talk about later on, is a resolution of the matter. Prior to the issuance of an order, the bishop and the respondent can reach an agreement for discipline. And finally, the bishop has other duties as assigned in the canon, and there are a bunch of them, none of them as substantial as the ones we've been talking about here, but still there are a bunch of places where the bishop does come into the system. The disciplinary board we spoke about earlier, it's elected by diocesan convention. If you're Maine, New Hampshire, or Vermont, we share one because we are smaller dioceses, and we've realized a number of years ago now that we collectively, that none of us individually needs our own disciplinary board because we don't have enough congregations or clergy to merit that level of homemade process. But also that among us, we are better equipped to elect and have good people doing that work. The president of the disciplinary board serves on the reference panel. The other thing the president of the disciplinary board does is to put together schedules for handling each referral and figure out who is going to be on the conference panel and the hearing panel. Those selections are often done using some kind of random selection, but there can be judgment involved as well. For instance, if there's a conflict of interest or a lack of availability of a member of the disciplinary board, the president, of course, can make sure not to create impossibilities by assigning people to work that they can't do. Next up is the conference panel. We said earlier we don't usually get to conference panels, but and that's true, we don't usually, we do sometimes. A conference panel is made up of members of the disciplinary board, not all of them, but some. Up to 3, it can be as small as 1. That always raises eyebrows because a panel of 1 seems like not really a panel, but nonetheless, it can be that. Essentially, if the matter isn't getting resolved by agreement between bishop and respondent, following other processes earlier on, the conference panel is kind of like a pre-hearing group that can call the parties in, look at the entire matter, and try to bring about agreement. That's the conference. It is described as an informal conference, but frequently if matters get this far, lawyers begin to get involved and informality can be suspiciously formal looking. Finally is the hearing panel. The hearing panel is indeed 3 members of the disciplinary board. They will be assisted by the church attorney, and the disciplinary board essentially is the closest thing we have to a trial court, and their processes are not informal. Their processes are notably formal. They think and talk in terms of evidence and adjudication. This is what happens if agreement is impossible, and we get to the end of the day and somebody has to make a decision over the object. I mean, you know, like any case in any court, you never get to trial unless you fail to settle, and most cases do settle. So our experience of hearing panels is happily very limited, but they happen from time to time. There are a few other participants in the system, and we'll talk about them more briefly. There's the church attorney, who is indeed a lawyer, chosen according to canons of each diocese, represents the church in Title IV proceedings, and has various other roles in the process. The church attorney is informed of practically all Title IV proceedings that come in, and is the advisor to the church itself at different parts of the process. Church attorneys have some degree of autonomy. They are there to some degree to sort of represent the interests of justice and to make sure that the system is well enough advised to do its work effectively. The advisor is not necessarily, and in fact isn't usually, an attorney. The advisor is offered by the bishop to help a complainant or a respondent to navigate this process. So it's somebody who knows how Title IV works, but they're not a lawyer. They're not an advocate for the person that they're advising. They really are a process consultant, and they can be really important. This process, when a clergy person is named in a complaint, that's a bad day for any clergy person. It's a scary day. There's the fear of humiliation. There's the fear of loss of livelihood if the matter is serious enough. And most clergy don't have any experience with this, and so they feel like they're getting swept into a process that is big and scary and unfamiliar. And the advisor is really important to help the clergy person know that there's somebody by their side who will help them navigate and help them not do things that they will later regret. The investigator is just what it sounds like. It's the gumshoe who the reference panel may send a matter to. When the intake officer takes in a matter, what the intake officer is doing is deciding whether or not this should be reviewed under Title IV, not whether it's truthful or not. That the intake officer doesn't do. The investigator is the one who actually goes and tries to figure out what actually happened. It's not always necessary. Sometimes it's obvious what happened and there's no disagreement about it and everybody's telling the same story, and the question isn't what happened, but what should happen. But if it's not clear what did happen, the investigator is often necessary to figure that out and to sort of lay out the story in a way that people can then look at together and decide what happens next. A conciliator is in some respects, it's a mediator. It comes before generally the conference panel. There's a little bit of functional overlap, but the conciliator is somebody who can work with complainant and respondent and try to come to an agreement, broadly understood, about what happened, what should happen. We've been using the word complainant. The complainant is the person who's made the complaint, the person who has complained to the intake officer. But it's a formal term, and I've been using it a little loosely so far. Somebody who in this process is referred to and treated as a complainant actually has rights to be informed and involved in the process. And that only happens if the person consents to having that role. So, so somebody who makes a complaint doesn't participate further in the process unless they choose to, unless they want to be named as a complainant. The respondent doesn't have the same kind of choice. The respondent is the person who is said to have committed an offense. So it's the member of the clergy who is the subject of a referred matter. That means something that the reference panel has received and acted on. Or somebody who has been the subject of any of the kind of process directions we were talking about earlier, like an administrative leave or a restriction on ministry, or somebody who has been, who is the subject of an investigation. The respondent basically is, we try to avoid legal terms here, but the respondent is the defendant in loose terms. That takes us to the end of the, we're still sort of at the beginning of the play. Like if you read Shakespeare in college, on the inside of the flyleaf, there was always the list of parts and players. That's what we've been doing so far. And obviously none of it really makes sense until we talk about what those different people do. But for that, I'm going to turn back to Robin unless people have questions at this stage.
Well, I'm wondering if we should just kind of go through a little bit of the process, because usually the questions people have about the participants that Michael just went through become a little bit clearer as we look at the process, because you'll see where the people, what each role does.
That makes sense.
So if it's okay with folks, if somebody's got a burning question right now, go ahead and raise your Zoom hand and we'll see that. Otherwise, I'll just continue on through the process, and then we will promise to stop screen sharing then and gather all the questions. But the slide that's in front of you, this is the first of the flow charts. And this flow chart says nothing more than all the things Michael just said about the participants in the role. So you see on the left-hand side, we got the disciplinary board. Okay, those are the people, there's a board in each diocese or a shared board through Mass, Vermont, and New Hampshire. So you've got that board. The president of that board, whoever that board elects as president, you'll see comes over into that right-hand box. They become a member of the reference panel. And the reference panel is really important. You'll see in a minute. There's 3 people on the reference panel: the bishop, the intake officer, and that president of the disciplinary board. They're going to make a lot of choices about what happens to a matter. They do not decide the facts. They don't decide who's telling the truth. They're just going to decide what process that's available to us will most likely resolve this matter. And then you'll see from the disciplinary board, this is just a visual, another way to think about this. From the disciplinary board, members are chosen to serve on a conference panel or hearing panel in a particular case. So that's just a visual that might help some people. Oh, we got questions, comments here. I think I'm going to forge ahead as I said I was going to. So here's what these people do now that you've learned about some of the people. There we've got the intake officer. They receive information, and the canons are clear. They can receive information in any way. It can come in anonymously. They could get it by email, phone call, any way somebody wants to get information to them. And every diocese has an obligation to make known to the diocese who their intake officer is. They have to have at least one. And as Michael said, ideally there's multiple people. So somebody who's got a concern has some choices about who to go to. So the intake officers, basically, I think of them as receiving information. They're going to talk to the person and they're going to say, would you like to be a complainant? Do you consent to be a complainant? And for intake officers, there's a page in the training manual with all the rights and obligations if somebody wants to be a complainant. One thing that will happen is the complainant's name will be released very quickly to the respondent. So there are sometimes people choose to be an unnamed reporter if they're fearful of retaliation. So there's some good reasons for people to say, here's my whole story and I don't want to be a complainant. So that's the intake officer's receives information, helps the person determine, do they want to be a complainant? Intake officer may conduct an initial inquiry. And the way we read that in Connecticut is that's very limited. They are not calling up people. They are not calling up potential witnesses or reaching out to anybody in the parish, but they might go to the parish website if a person's called and said, Rector so-and-so is doing this or that, might go and look at the parish website to see indeed, is that person the rector there? They might do a little bit of sort of online research, but certainly no reaching out to individuals. And that intake officer must write an intake report. This is true even if what the person has complained of, the intake officer is thinking, this is really not an offense. This person's really unhappy about something a clergy person did, but does not constitute an offense. They still have to write an intake report. So they've got a good amount of work to do. And then they're going to look at their intake report. And they're going to look at it in just at this point in the process. And I can't emphasize this enough because clergy are presumed innocent. Except this one point in the process, the intake officer is going to look at their report and say to themselves, if all that's been told to me that I've written down is true, would this constitute an offense? Remember, it has to be material and substantial or clear and weighty or fall into those categories somewhere. Or if it doesn't fall into a category, but it's still really kind of a bad thing, it can be conduct unbecoming a member of the clergy. So we're going to say for a minute, they look at their report and say, this is not material and substantial, not clear and weighty. So I'm going down the left-hand side here. If they decide, the intake officer says it does not constitute an offense, they can form an intent to dismiss the case. They have to run it by the bishop. They have to say, Bishop, this is what's come into me. I think I'm going to dismiss it. If the bishop agrees with that, the intake officer can dismiss the complaint. And the intake officer at that point would send a notice to the complainant, if the complainant has been designated a complainant, to the president of the disciplinary board and to the cleric, letting them know that the matter has been dismissed. The intake officer can retain copies of all those documents because there have been cases where multiple things have come in over time. And the first thing that came in didn't sound all that serious. It didn't sound material and substantial, but by the time you get the 12th report about behavior that didn't sound that serious, but now we see it's a pattern that might change. So the intake officer can keep copies of all that. If the complainant wants to appeal that dismissal, they can. They would be given an advisor, who Michael explained earlier is somebody who has some experience and understanding of the Title IV process. They would prepare their appeal, which the canons say exactly, you basically write it up and who it needs to be sent to. That appeal goes to the president of the disciplinary board. So remember, there's 3 people on the reference panel, the bishop, the intake officer, and that president of the board. The intake officer already talked to the bishop about dismissing it. So now the check on those 2 is the president of the disciplinary board. They get the appeal. They could affirm the dismissal or overrule the dismissal. If the president of the board affirms the dismissal, that is the end of the matter. And the complainant doesn't have anywhere else to go in this Title IV process. And I will say there are times when complainants are very unhappy that their case has been dismissed. This process, as Michael set out earlier, is about amendment of life. It's restorative justice. If there's somebody who's out to get even, they're not going to be happy with the Title IV process. And I can talk more about that, unhappy complainants, when we get to the questions and answers section. But let's assume that the president of the disciplinary board overruled the dismissal. The matter would now go to the reference panel. And That's the same result as if you look at the right-hand side of this flow chart. If the intake officer looks at their report and says, well, this would constitute an offense if all these facts are true, the intake officer sends the report to the reference panel immediately and is to send a notice at that point to the clergy person, letting them know the complaint, not sending the intake report, but letting them know the nature of the allegations. It would identify the complainant. So that's why the decision of whether or not to agree to be designated as a complainant is pretty darn important right early on. Why don't we stop? We'll stop and do some questions now, and then we'll pick up the second part of the. Thank you. So folks, where we left off, the matter had come to the reference panel. Okay, and so now the question is, what the heck is the reference panel going to do with this? And just as a reminder, the reference panel is 3 people: the bishop, the intake officer, and the president of the disciplinary board. So when the matter goes to the reference panel, they are supposed to meet as soon as possible. In Connecticut, our reference panel meets once a month. Other places, other dioceses will do it differently. Right up front at the beginning here, the president of the disciplinary board is going to choose people from the disciplinary board to serve on reference panels and hearing panels in a particular case as soon as it comes in. So there's no judgment about, is this case likely to need a hearing? Every case that comes in, the president makes that decision right up front, which means those of you who are on disciplinary boards, you may get an email from the president saying, you have been assigned to a conference panel or hearing panel, and here's the case number. At least in Connecticut, we just send out a case number, so nobody knows the identity of the complainant or the respondent. And that's pretty much what happens as a disciplinary board member. Usually, as Michael said earlier, cases don't go to a conference or hearing panel. They get resolved some other way, and we'll look at those other ways in just 1 minute. And if it does get resolved, you would then get an email from your president of the disciplinary board saying, thank you for your service, the matter's been resolved. And if your case is going to go to a conference panel or hearing panel, you would get a different kind of an email. Michael suggested that the selection of who's on the disciplinary board and conference panel can be random. When the canon was first passed in 2011, it said the choices had to be random by lot or other random means. That was actually the language of the canon. And they've been revised so that the president can actually use some discretion in figuring out, who do we want to put on a conference panel together, or who do we want to put on a hearing panel together, so that there's some balances of gifts and skills there. So the reference panel is going to meet, and they are going to decide. You see, it says here by majority vote. So we got to get 2 people to agree. And again, the question for this reference panel is, not who did it, not who's telling the truth or who's not. It's what process within Title IV is going to make the most sense to try to resolve the matter. And you'll know the first option that they have over here on the left-hand side is they could decide we're going to take no action other than appropriate pastoral response. So they could decide, okay, yep, intake officer decided this was an offense. This may be an offense. Somebody may have, I'm trying to think of the matters that go to no action. It's obviously not a significant violation. And the appropriate pastoral response can be incredibly involved. It might be working with the complainant if there's been a breach of trust in the community. It might be working with the congregation. It might be that the ordained leader is going for some kind of training, counseling, some kind of follow-up. And if the reference panel sends it there, that's the end. there's no right of appeal for the complainant. That would be done. That's one bucket. I think of these as like 5 different buckets. The next bucket is conciliation. And Michael referred to the conciliator as kind of a mediator. Conciliation is probably most appropriate when you're talking about a breach. There's been a violation. It's an offense that it usually involves 2 people, nobody beyond the 2 people, and somehow it's appropriate to bring them together with a trained conciliator to see if they can work out an agreement or an understanding together about how to move forward. This obviously is not a choice where there's significant abuse or violation on the part of the clergy person. I can tell you when we first started with this version of Title IV in 2011, I was the intake officer. And one of the first intakes I got was a complainant saying, I need to be reconciled with my rector. And I see online where you've got information about Title IV, it says it's about reconciliation and amendment of life. And the person went on to say what the rector had done. And indeed, the rector had way overstepped to become this person's lifeline best buddy. And then when the lay person who was a senior warden at the time voted against the rector on something on the vestry, the rector withdrew all kinds of support. There were other issues there, but it was actually appropriate to see, can we figure out a way for these 2 people to go forward? And conciliation is not an easy process. It involved, in that situation, when we use conciliators, we have teams. We always have a team of 2. They generally meet with the complainant first and the complainant's advisor, then meet separately with respondent and respondent's advisor, and then may bring the folks together if they think there's a chance that conciliation, like any kind of true reconciliation, requires a true change of heart, an understanding on the respondent's part about their behavior and the impact it had on somebody else, and a willingness to change that behavior. It also likely involves the complainant saying, oh, I can maybe do things differently too going forward. How are we gonna have a new relationship here? So it's not an easy process. Christian reconciliation is not an easy process. And in the process I just described, the conciliators actually gave both parties written homework. They had to identify what would any kind of reconciliation look like going forward, and what external factors would get in the way of that, and what internal factors. So it was pretty deep process. And I have seen, we've had a couple cases go to conciliation, and one of them was pretty successful, and the others, I would say, people made real good faith attempts and were not able to resolve the matter. We're going over 2 buckets that the reference panel have: the no action bucket, conciliation bucket. And the conciliation, I would say, that's a small subset of the matters that are going to come into a reference panel where that would be appropriate. The next bucket is investigation. And this is where you would get the professional investigator would go out and find out what the heck happened. We've used investigation in situations where there's been allegations of financial impropriety, where we had to find out, like, if this is true, yeah, this is a big problem. We don't think this is all happening, but it can look different, like different things. We've had cases of allegations of sexual misconduct, and in those situations, we did have one investigation where multiple people were interviewed to figure out what was going on. And it's just those situations where the reference panel looks and says, we can't really tell what process will resolve this unless we have a clearer understanding of facts. The investigator is actually working for the reference panel. They go do the investigation, produce a report back to the reference panel. The reference panel could say, investigator, we want you to come in so we can ask you questions, and they can ask for further investigation. So that's when the reference panel can't really make a decision without knowing with more clarity what are the facts. The fourth bucket available to a reference panel is to send the matter to the bishop to see if the bishop and the respondent can meet together to come to an agreement about terms of discipline. So this is where it's just what, like it says, the bishop would reach out to the respondent. The bishop might say, in my experience in these situations, the bishop says, respondent, here's what I understand happened. And here's what I think are ways to hold you accountable and to help you amend your life and find a new way going forward. If the clergy person, the respondent says, yes, I agree, and this is an agreement, that word agreement is important. This is not strong arming a clergy person. Nobody's forced to make an agreement. It's an agreement. If the clergy person says, I agree with that, or bishop, how about this? What if instead of like going to that training program or that therapy or whatever it is, I did this? There's some give and take. If they come to an understanding, they're going to write up that agreement and it becomes what's called an accord, which is just the word in Title IV for an agreement. That would end the matter. Okay. The last bucket they have is called the conference panel, which we will talk about a little bit more in a minute. But Michael alluded to this earlier. The conference panel is described in the canons as an informal conversation. And now, remember, this would be being run in Connecticut. When we have a conference panel, we always put 2 people on the conference panel. We don't want to have anybody try and do this by themselves. So that would mean we've got 2 people from the disciplinary board who haven't seen the matter before, would be sitting down with the complainant, if there's a named complainant, and their advisor, the respondent and their advisor, and attorney if they have an attorney. The conference panel can decide, we're going to invite in other people. We think that we need the vestry here to help resolve this matter. Because there are just situations where you might want to bring in other people from the community. And at this conference panel, the church attorney has to be invited and has a role. Before the conference panel happens, the church attorney actually prepares sort of a charging document so they know what the allegations are. Now, the challenges that Michael alluded to earlier with having an informal conversation when you have a church attorney and an attorney for the respondent, it's just really hard because attorneys are not generally trained to have informal conversations. They're trained to be an advocate for their position, for their client. So it can be challenging to have what truly I would consider an informal conversation. The goal of that conversation is to come out with an agreement, to see if we can come out with an agreement, just like the agreement the bishop was going to make with a respondent in that earlier bucket. Here, they're trying to come out with an agreement. The agreement here would be signed by the church attorney on behalf of the church. The bishop's not even here at this. Be signed by the church attorney, the respondent, and then the president of the conference panel. So whoever's there running the conference has to be agreeable to 3 parties to settle it at this point. Okay, and it would be coming out with an accord. If they came out with an accord, that would end it. And what I'm going to do now is, if we were live in a room and I had like this huge piece of flip chart, which I used to have this chart that went from the ceiling to the floor, so you could see this all in one chart. I'm just moving down to the second half of the chart. So I've not done anything but moved us down to the second half of the chart. And I'm going to go through those 5 buckets again to see what happens here. So again, if it went into the first bucket, no action, there's no next steps. If it went into the conciliation bucket, technically you're after an accord. You're trying to work out an agreement. If they do not work out an agreement between the respondent, the complainant, and the conciliators would sign off on it, it's going to bounce back to the reference panel. So if any option that the reference panel picks does not resolve a matter, kind of in short, it bounces back to the reference panel to decide, well, now what? Investigation, I said earlier, the report comes back. The reference panel, once they have that investigator's report and are satisfied with it, they can then decide, all right, which bucket do we want to refer this to now that we think is, which process do we think will resolve it? And after an investigation, they do have the choice of a hearing panel. And again, the hearing panel is the most trial-like process. This is where the church attorney represents the church and kind of acts like a prosecutor. There are witnesses called to testify. It's the closest thing the Episcopal Church has to actually having a trial on a matter. That is obviously not the goal of Title IV. The goal of Title IV would be, let's see if we can have a change of heart, have an understanding of how people's behavior has impacted other people, have people take accountability and figure out how are we going to amend lives. And if somebody says, yep, I'm not agreeing that I did any of this, or maybe I did it, but you know what? I don't think I should be held accountable for anything. That's when you might land at a hearing panel. And again, I think it's important to note the reference panel does not have this option originally. It's only after investigation that it could go down to a hearing panel. If it's been sent to the bishop for possible agreement, if they come out with an agreement, great. If they try and it doesn't resolve in an accord and an agreement, the bishop has to report back to the reference panel. I tried, it didn't work. We now have to pick something else. A few pieces about this. The thing about an accord is, particularly like around conciliation, when I first was reading the canons after this process was designed, I thought, wow, this is a really good idea to just, in some settings, some situations, get the folks to sit down together with some trained folks and see if they can't work out an agreement for going forward. If, however, after conciliation, you come out with an accord, anytime there's an accord, a notice gets sent out to almost everybody in the Episcopal Church to let the church know that clergy person has entered an accord. It does not include the terms of the accord. The actual accord doesn't get sent out to everybody, but a notice of accord goes out. And because the former Title IV dealt with very serious conduct only and not violations of professional boundaries and conduct, I think the church still responds to notices of accord as like something really bad must have happened. So frankly, in our conciliation cases, we did not resolve matters by going all the way to an accord because we didn't think a notice should be sent out in those cases. And so what would happen is the conciliators would do all their work. We'd make great headway in some cases, made great headway. And then the conciliators would send it back to the reference panel and say, we've made great headway. This is what we've done, but not reduce it to an accord. And the reference panel got it back and would say, okay, we're going to send this for no action other than appropriate pastoral response. And the bishop followed up that pastoral response by issuing a pastoral direction saying, clergy person, you agreed to this new way of life and these new boundaries. Here they are, live into them. So it was a way to, I think, follow Title IV and not have a notice go out that would have flagged this person throughout the Episcopal Church with a Title IV matter when the underlying relation was there was an offense and it was a professional boundary violation, not significant misconduct or abuse. The same is true if the bishop comes out with an accord, a notice goes out about the accord, and the notice would be sent to every clergy person in the diocese, every vestry in the diocese, every bishop across the Episcopal Church, And then some of the central church offices, like Michael referred to earlier, the transition ministry folks, like it pretty much goes everywhere. And the goal is to make sure that all the church knows when there's been a significant Title IV matter. And I'm now going to go to that fifth bucket for a minute, the conference panel, and you can see, again, their goal is to try to come up with an agreement. If they come up with an agreement, it's called an accord, and that notice would go out. And this time, the accord, as I mentioned earlier, is signed by the church attorney, the respondent, and the conference panel people. If they don't get an accord, those conference panel people are supposed to deliberate privately. They could dismiss a matter. They could say, we don't know why the reference panel got all bothered about this, but here are our reasons. They have to give a written statement of why, but they could dismiss a matter. They could on their own send a matter to conciliation, or they could say, we're referring it to the hearing panel. I mean, we've tried, to get an agreement. It's not happening. We're sending it to the hearing panel. And the conference panel also has this really weird thing. They can issue an order, but I don't even think about it as an order. I think about it as they can issue a strong suggestion, because if they issue an order and the church attorney or the respondent doesn't like it, they can object to it, and then the matter would go straight to a hearing panel. So it's not much of an order if two of the parties can object to it and it has no weight. It would just move things to the hearing panel. That was a lot of information. I think what I might do is stop screen sharing and go to questions. But the key point I want to impress upon you is that notice across these boxes, the bishop is in some of them and has a role, like bishop for possible agreement, or if there's sometimes the pastoral response follow-up is going to be the bishop. But if a matter is sent to conciliation, bishop's not there. If the matter goes to the conference panel, the bishop's not there. Other people are running those processes. So this is designed so the bishop still obviously has a central role and is not the only person making decisions about a case. So I think I'm going to stop sharing and we'll take questions. I mean, that